Okay, good afternoon, everyone, or good evening shortly, and welcome to our session on the International Court of Justice. My name is Daniel Bloch. I'm the Executive Director of the Cape South African Jewish Board of Deputies. Most of you know me, if not all, but we do have several hundred people tuned into Zoom, so welcome to all of our guests on Zoom and to all of you in audience. Special welcome to our Vice Chairs, Glenn Heddick and Simon Salkas, and an apology from the Chair, Adrian Jacobson, who is ill at home, but she's on Zoom. Also want to acknowledge other members of our council, Lester Hoffman, Jonathan Silk, Viv Anstey. I think all protocol is observed. And finally, to welcome our speakers. So firstly, to Judge Dennis Davis, who's an emeritus professor of law at UCT. And I cannot read out his CV because that would be like reading out the list of Manchester United accomplishments, which is quite long.
Very short indeed, yes.
And also to the South African Jewish Board of Deputies National Vice President, Mary Klook. Mary, thank you for joining us.
Thank you.
And they will be having a discussion on the International Court of Justice. So we do know that last week was quite an intense week, to say the least. I think the world's eyes were all on Thursday and Friday, watching proceedings at the International Court of Justice. Recording in progress, yes. And where was my train of thought? And obviously, regardless of what your opinions are, your beliefs and ideas about what took place on Thursday and Friday, I think the consensus is, within our community and generally around the world, what is the International Court of Justice? What does Thursday and Friday mean, in particular for South Africa and Israel? What are the processes? And hopefully tonight, Judge Davis and Mary are going to explore the do's and don'ts, the ins and outs, the legal ramifications, and have an overall general discussion about what took place last week and what we can expect over the coming days, weeks, months, and years. What we can do is, if anybody has any questions online on Zoom, you've got the Q&A chat function. Please put your questions into there, and we'll endeavor to answer as many as possible. And from the audience, if you do have any questions at some point during the evening, I'm sure Mary will know when the break is, we can take a few questions from the audience. Lastly, please, if you can keep your phones on silent, and if you do need the bathrooms, go outside and around the corner, and there's still plenty of tea and coffee and biscuits outside. So without further ado, Mary, handing over to you. Thank you.
Thank you, Daniel, and welcome to the audience here in person and obviously to everybody on Zoom. And thank you, Dennis.
Pleasure.
It's a really important conversation. It's a conversation that has, and a case that has gripped the world. And we are, as I think I said to you, many of us spent our December holidays fast-tracking our capacity or our skills as international law experts, because we had sight from the 29th of December of the South African 84-paged document that South Africa submitted to the ICJ, and so we have obviously had sight of a lot of that content. But I think before we get into the content and the substance of the case, which I'm so interested to hear from you, and as we all are, I wondered, most of the audience, no doubt, have been following the case very closely, but there may be a few people who are not as au fait, and I think it would be helpful if you could just talk us through who is the ICJ, what is it comprised of, how does this process of this case in fact work, and then from a kind of tag on is, who are the judges and how are they appointed?
Sure. And thank you very much. And thank you for clarifying what we're trying to do this evening, which is not to have a moral argument about who's right and who's wrong, because that just goes nowhere, as we've seen. It is to try to talk a little bit about what the law is in this regard and what this process is about. And of course, you're quite right. I'm reminded, if I may start, by saying one of the remarkable features about a high-profile case are two aspects. Firstly, every lawyer who appears in this case is regarded as the greatest of all time. You may think about the Pistorius case. I won't embarrass you if I asked you who the advocates were at the time, but at that stage, everybody thought they were the greatest criminal lawyers of all time. Those of us in the business knew that wasn't so. The second part is everybody's an expert in international law. Just like they were about dolus eventualis with Pistorius, now everybody's an international law expert, even though they've never read one case of the ICJ. And I have to say, a lot of the South African commentary has been absolutely embarrassingly poor, precisely because people think they can talk about that which they know nothing about. So it's useful to have a conversation where let's get the facts clear. So Mary, the ICJ, the International Court of Justice, or is known the World Court, and some of you old enough like me will remember the 1970s when South Africa was taken to the World Court because of the Namibian Southwest African issue. It's the same court. It started in 1946. It has 15 members. They are chosen, five of them every 3 years. So it's sort of a 9-year term. And they're chosen by a majority of the General Assembly and the Security Council together. So that's how you get there. And in fact, Professor Tlodley, who's a South African, is going to get onto that court in February. He wasn't available this time. So they are chosen by that group. And they have jurisdiction, obviously, over certain international treaties. Certain they don't have. For example, some of the criminal statutes go to the International Criminal Court. And we can talk a little bit about that because it's not irrelevant to this topic as a whole. But they certainly have jurisdiction to deal with the Genocide Convention. And we'll get to that in a moment. So, obviously, in addition to the 15, a party who doesn't have a judge, but who's a party to the dispute, is entitled to appoint a judge, hence Judge Moseneke on the South African side, Judge Barak on the Israeli side. You have to sort of say it's a pretty two damn good appointments, one way or the other. Judge Moseneke, who in my view tragically was not the Chief Justice of South Africa, the Chief Justice we never had. Judge Barak, who obviously is one of my judicial heroes, although I cannot help but feel at this particular venue, I was chastised by certain people during a Limud talk, talking about the judicial review issues about Judge Barak, but truth about it is those of us who are lawyers also regarded him as one of the great judges of his time. Question is, who are the other 15? So I went through them, and I'm going to do this deliberately, Mary, because a lot of rubbish has been spoken about these judges.
So can I just interrupt, and can you weave into your analysis of
Yes.
the judges whether there is a potential for them to be politicized?
I'm going to talk about that too. I am. But a lot of rubbish has been spoken about this. Disparaging the judges that don't all come from democratic countries and what competence do they have. And I'm always anxious about that because there's a kind of inherent almost superiority or racism about this. We want certain judges, not other judges. And actually, in many cases, you're going to be quite surprised. So let me start off. Judge Donoghue, who's the presider, obviously comes from the USA, and she's had a long history within the State Department as a legal advisor, etc. Judge Georgian is the Russian, and you talk about independence, well, he is entirely Russian educated. No sense of any education outside of Russia, and has clearly been an apparatchik for the entire period, and you can draw your own inferences in relation to him. Then we get to Judge Tomka from Slovakia. He has a PhD from the Charles University in Prague. He's been part of the Hague Academy of International Law since 1987, and he's published quite widely in a whole range of reputable journals. Then there's Judge Abraham, who's the French judge, born in Egypt, I might add. He is a professor of international law in Paris. He's been a judge in the EU. He, too, is somebody who, again, is a specialist in international law with a string of academic and publishing qualifications. Then there's Judge Benouma from Morocco. Right? He's a professor of international law in Morocco, but what is interesting about him is there's a string of publications also in all sorts of reputable international journals. So we are not talking here about somebody who's just an apparatchik. This is an impressive set of credentials, backing up, I might add, what a couple of international lawyers who I know well and who've appeared in the ICJ tell me, that some of these people are actually very, very fine judges themselves. Then there's Judge, where's this? I'm just trying to work out where this one comes. Oh, yes. There's Judge Ahmed from Somalia. And what is interesting about him is that his entire legal education took place in Switzerland and the Netherlands. So his entire international training has taken place there. Right? There is then a Judge Han Queen from China. It's interesting in her particular connection that she has an LLM from Columbia University in human rights. So you ask me, where does she sit in the grand scheme of things? I don't know. But all I'm saying is this is somebody who's been exposed to a broader level of jurisprudence. Then I'm just trying to see who this one is from. There's Judge Bhandari from India, who has written extensively. He's got a master's degree from Northwestern University in United States, and he's been professor of law at one of the leading universities in India. There is Robinson from Jamaica, long-standing practice in Jamaica, educated in the UK. There's Judge Salam from Lebanon, who interestingly was educated at Sciences Po, which is, I certainly think, is a serious university, particularly serious because I'm going to go there as a visiting professor in Paris. So, and it's a proper place. And he's also taught at the American University in Beirut, which is not unimportant either, because that's a very independent institution. Then there, you get the others.
I know there's an Australian, I think.
No, I'm coming to her.
Okay.
Then there's Judge Yuji from Japan. She's Tokyo and Harvard educated. She has visited at Cambridge and Columbia with a long-standing academic career. Judge Nolte, who is the German, is professor of international at the Humboldt University in Berlin. He has been a member of the International Law Commission. Again, a huge list of publications. Judge Hilary Charlesworth from Australia, truly one of the outstanding international lawyers in the world today. Professor of international law in Melbourne. He's got a string of publications, and certainly I know her well, and she is an absolutely fantastic international lawyer. And there's Judge Brand from Brazil, who is a PhD again from Nantes University in France. He's been a professor of law in Brazil, again widely published and participated in a whole series of international tribunals. And I'm just trying to think of there's another judge, I'm just trying to think where they came from because I didn't write it down properly. Judge Sabuntinda, who has, interestingly enough, she has an LLM from Edinburgh, but an honorary LLD from the University of Edinburgh itself, and a lot of educative experience. In short, I've mentioned this in painstaking detail because I truly resented some of the videos, and I'm not mentioning who because I'm trying to be as right, Sam, this idea, who are these people? When I read this, and I mean no disrespect, I thought to myself, gee, I wouldn't mind many of these on our courts, right? And so it's wrong to suggest these are just a bunch of political hacks. Of course, I can't tell you. I'm sure the Russian must have a long conversation with Vlad. I have no idea whether the Chinese judge is under instructions. But I want to just make one other point, Mary, if I may. I'm now on the appellate court of the African Trade Court, which is just a year ago. 52 of the 53 nations of Africa have now got this African Trade Union agreement. The South African government, for reasons I don't quite understand, nominated me. Believe it or not, we had to go through a written and an oral exam, which 40 years after writing an exam was a traumatic experience. I'm now sit with a whole bunch of African judges. And the thing from all over Africa, and what strikes me about all of them, how fiercely independent they all are, and how annoyed they are by the bureaucrats who give us trouble. So I'm just simply saying, you can't argue here that there aren't some really impressive people. And of course, then you've got the other two, that's Barak and Moseneke, who I've spoken to. So those are the 17 judges that are going to decide this. To what extent are they influenced by politics? I think all judges to some extent are influenced by politics, to be perfectly blunt about it. The extent to which they are, I can't possibly tell you. I do think there are obviously ones who will, and there's ones who won't. I will be watching for some of them to see where they come down. For example, Judge Charlesworth, who I have the highest regard for, the German and the French, and one or two of the others particularly. But I think it's fair to say that those who come from developing countries have very impressive records and cannot simply be regarded as sort of apparatchiks. So you then ask me, well, what then happens? They get the case because both South Africa and Israel are signatories to the Genocide Convention. And there are two aspects of that, if I could just touch on before you ask the next question. Many of you may have read the book by Philippe Sands.
Oh,
Right,
loved it. East
right?
West.
One of the great, by the way, who appears very often before the ICJ. And you will then, if you've read that book by Philippe Sands, know that much of the book is devoted to the same two people who came from Lvov, Lemkin and Lauterpacht. And to put it, just why I mention this is because the big issue at the time of Nuremberg was, should the Nazis be charged under crimes against humanity and war crimes or the Genocide Convention? Lauterpacht was the former. He had developed international law to deal with crimes against humanity and war crimes, and those are not irrelevant because they are now the subject matter of the Rome Statute and, of course, the International Criminal Court. And I can tell you that there has been a case lodged before them insofar as this matter of Israel is concerned. And that's a totally different matter. We can talk about that in a moment. The second part about it is that Lemkin developed this because of the Holocaust. And of course, therefore, there's a deep irony in all of this. But the point about this I wanted to make was the Lauterpacht argument is very problematic to prove collective kind of guilt of that kind, meaning you can say, I wanted to kill everybody in this room, but could I say I wanted to kill everybody in this room? I stress this is totally hypothetical. If you all because you were all Jewish, or you may not all be Jewish, but I'm saying assuming that you were, the anxiety was that. And of course, that is one of the issues which obviously floats around. But that's the background, if I may, to who the judges are, what their jurisdiction is. And we do, of course, have many judgments that they've written, some of which we can talk about, which will give us some guidance in this regard.
We'll talk about that,
Yes.
obviously. I just
Yes.
wanted to say, I don't think we mentioned the name of the book. It's called East West
Oh,
Street.
God, I was having one of my senior
So-
moments, East West Street,
Yes,
yes.
it's called East West Street. So for
Thank you.
anybody who's interested in or hasn't read it,
Yes.
it's certainly highly
Yes,
recommended reading.
absolutely.
So just flowing from the actual nature of the court and how it proceeds, and you mentioned the judges in the Oscar Pistorius, or not the
Yeah.
judges, the Mr. Barry, whatever,
Yeah,
and,
yeah.
yes,
God
and
knows, yeah.
Mr. Nell, or whatever. So one would expect. that
Glynis will know who they are.
Yeah.
They would have been her opponents over the years.
but the point is that we know what that entailed, and
Yeah.
it became a months and months and months. So what I'm asking is, we'd expect a case of this nature to involve weeks of detailed testimony and presentations of evidence and argument, but this is the RCJ is adjudicating on the basis of South Africa's written 84-page submission that I referred to, that was lodged on the 29th of December, and a brief oral submission on the first day, followed by South Africa's Israel's oral submission the following day. And leading aside the actual parties to this case, the court's being asked to make decisions that are going to have far-reaching implications, not only for the parties, but international law regarding armed conflict going forward. As a judge, how does this work?
Okay, well, you've asked a very important question, because I fear here that the answer to your question is very central to what may happen. In other words, let's assume, just for the purpose of debate, that South Africa win parts of its case. And I stress, I think it's more likely that they can win some than others, but we can come there. Then, of course, the question will be, does that mean that Israel is guilty of genocide? And the answer is no, in point of fact, because what is being asked before the court at the moment is for the court to give provisional measures. Now, there are lawyers in the room, but if you aren't, let me explain something to you. In South African terms, it would be that you go to court for an interim interdict. So you go along to say, my neighbor is having a party till 3 in the morning every morning. I want them to stop. Right? The judge is not going to decide, who's right and who's wrong. The judge would say, is there a prima facie case? Do you have a right which at least deserves a certain measure of protection? And you would look at that, and then you would ask yourself, the balance of convenience and who will be benefit or who will be harmed the most if I give the order, don't give the order. It's an interim order pending a proper hearing in which the merits of the case will be decided. And this case has been brought on that basis. I'm simplifying it in terms of what's called provisional measures. In other words, South Africa is not asking at this stage for Israel to be found guilty of genocide per se. What it is saying is that there is a justifiable breach of the Genocide Convention of a kind that would justify the court taking provisional steps to mitigate the potential harm that could be caused by our prima facie finding, because, as it were, rather protect people than don't protect people against this. If you can find, that is the court, you can find what we call a level of plausibility. I'm going to come to that in a moment. But it's because of that that the case is fought out on paper. In other words, this is not a trial. Obviously, if this case goes ahead, it would take years, because you'd have to have evidence of all sorts of kind brought on both sides to show precisely whether, in fact, the convention has been breached per se. Here, what is being asked of the court is there sufficient evidence on the papers to justify a provisional measure to, as it were, protect the harm from continuing, harm that you as a court have found prima facie exists. Let me give you an example, a case that was cited very often on the hearing, which was the Gambia-Myanmar case. Now, there are a couple of issues. You may remember that case had to do with the Rohingya people who had been obviously unbelievably persecuted for quite some time, and the United Nations, all sorts of independent observers, said that this was a genocide. There were two aspects about that case that are relevant. The first was, in case you're worried, because some people will raise this point at some point, the question was, well, it was said, who the hell are you from Gambia to come along and bring this case? You're not exactly the personification of democracy yourself, and on what particular basis have you got any interest in what's going on in our country? And besides which, you haven't been so fastidious in the compliance with this convention, even if you're a party beforehand. And the court said, something that we lawyers talk about, the doctrine of clean hands, that you come, as it were, in a perfectly pristine position to argue the case and that you don't have any ulterior motives, is irrelevant. What is relevant is there a dispute between two parties which we are obliged to hear on the facts, as it were? That's number one. Secondly, they said, on the facts as we read them, on the reports that have been made available to us, there is sufficient plausibility to say, yes, there is a breach of the convention. We do not say that is our final decision, but it is sufficiently on the papers such that we can justify the ordering of provisional measures. To take it further, and I'm just going to quote a couple of cases in this regard. And why this is so complicated is because, to a large degree, the ICJ has not exactly been, if you could, to put it bluntly, coherent in this particular connection. Meaning, I've been reading all these cases and I've taught some of them over the years, and it's hard to know precisely what the ultimate test is of plausibility. Right. In other words, in the Myanmar case, this is what the court said. It would seem that the plausibility of the rights claimed as a prerequisite for the indication of provisional measures is by now quite firmly anchored in the court's jurisprudence. That may not be entirely true, but just the court goes on. At the same time, it would seem that questions remain open regarding the precise scope of the requirement, and that remains a challenge to describe the court's standard of plausibility with precision. So the first difficulty we've got is, what does the court mean by a plausible case that has been brought by South Africa? The second point that has to be brought about is, does that mean that you've got some prospects of success in the final case?
Are you talking from a perspective of South
Yes,
Africa?
in an ordinary interdict, the kind of case I've spoken about, you'd have to show that you've got prospects of success in the final analysis, otherwise the judge may not give the order. And there are different approaches taken by the ICJ to this regard. Some say you have to show that. Others say we should lean in favor of bringing about protections to the particular party concerned, the aggrieved party, and therefore the standard should be lower. What is absolutely clear, and that's terribly important to understand, this legal standard that has to be applied in this case is not a reasonable doubt standard, it's not even a probability standard. It's a much lower standard in order to justify provisional measures of the kind that South Africa has asked for.
So you said earlier in your explanation that if there is a case, what do you mean by if? Is there a possibility that in this application for provisional measures, the court could opine that in fact there is no prima facie case, and so there's no need to pursue the discussion about genocide?
Well,
what did you mean
the
by
court
if?
would have to say, again, quoting from the Gambian case, the court would have to say that there isn't a sufficiently plausible claim made by South Africa that the right of the Palestinian group to protection from acts of genocide and related prohibited acts have been shown on the papers. That's what they would have, that's what the court would have to say. Now, it may be, let me put it this way, some judges may say, look, this is a case where there may be war crimes. This is a case where there may well be crimes against humanity. But this isn't a case of genocide. We don't say that there's crimes against humanity or war crimes, but we say those are more plausible than the Genocide Convention, and accordingly, we would find that it's not a plausible case. Judges may say, however, that the standard is sufficiently low that the harm which has been caused by the Palestinians to the Palestinians to that extent has been sufficiently met, and they will decide that on the papers.
Okay.
Yeah.
So that will be the decision to decide whether they're actually going to grant any provisional measures and pursue the case at all.
Well, there are three options you have, really. The one is that the court dismisses the entire case. I'd be extraordinarily surprised if 17 judges did that, to be honest with you. Right? It is possible the majority may. I don't know. And one of the reasons we don't know is because this is a court where no judge asks the question. So, in an ordinary case, you sit there and, within half an hour, you know exactly, what's happened. I mean, I know judges say, a lot of counsel said about me, that within 20 minutes of the case, they have a pretty shrewd idea which way I'm going. And many judges, that's true. But here, nobody asks the question. So you have absolutely no idea what the court's thinking, what individual judges are thinking, etc. So what I'm trying to say is, I have no idea. But there's one possibility is that they say, you haven't met the plausibility standard. Now, how would they do that? Let's start there. They would have to say that on the Genocide Convention, whilst the acts of Israel are such that they may fall within breaches of international law and international humanitarian law, they haven't met even the standard to get within genocide because we're anxious. Otherwise, in a sense, everybody runs to genocide as a start. That's a possibility.
That's what I was going to ask.
That's a possibility. The second is that the judges say, no, Israel has met, South Africa has met its case on the facts, on the low standard of plausibilities I've indicated to you, that they don't take the question of prospects of success to the extent that they look at the protection of a vulnerable group as a greater thing. And let me just say this about that. if you could just, I know it's hard to do this, but abstract yourself from what your own position is here. If you were a neutral judge, the temptation to actually do something to stop killing is enormous. It just is, right? I mean, having sat for 25 years as a judge, I just know that you look and because what wins cases is whose moral argument do you buy, right? So that's the possibility. I'll come back to the first argument in a moment. So the second is you buy the South African case and you give them what they want. The third, which a lot of commentators are suggesting, is there will not be an order for a ceasefire because the Israeli case showed that would render Israel utterly vulnerable, assuming it was enforced, which it can't be, by the way, because
So we'll come to the...
Yeah, but assuming, but that can't possibly be the answer, but it may well be tempted, if you look at the provisional measures that South Africa's asked for, humanitarian aid, certain strictures on what can be done, they may well be tempted to do that. So those are the three possibilities, Mary, that could actually, the court could go. Just one final point about the genocide, the first one. I think the complexity of the case, which ultimately was the Israeli argument when you drill down on it, was what is a country supposed to do if the other side has genocidal intent? In other words, Hamas. How far can that go? The South African response to that is, yes, you have a right of self-defense, but it cannot extend to the breach of the Genocide Convention. So we're back to that kind of decision yet again. Yeah, sorry.
No, I'm particularly interested in the Israeli defense because, as we discussed, we had so much exposure, or so much more exposure, to the arguments that were going to be provided by South Africa, and obviously were sitting glued on day 2 to hear for the first time the route that the legal route that the Israeli team would take. The two particular issues that I'm interested in, the one you touched on, which is the dispute issue, how they argued and what was the relevance of this argument. What was Casey Shaw, what was he driving at by saying that they couldn't show a genuine, he used, in fact, the language of unispute in some sort of jest. And then the other point that I found fascinating in terms of the Israeli defense was what happens, and this is layman's terms, what happens if interim measures are granted and subsequently in 2029 genocide is disproved? But you've now granted a country with punitive measures, and there was an example cited that, in terms of World War II in that case. Had there been provisional measures granted in the midst of a dreadful war, that would have put a stop to it. Possibly we wouldn't have got rid of Nazism, etc. Am I making...
No, you're making perfect sense.
So those 2 points I'm really interested for the audience and myself to hear a little of your explanation.
All right, well, look,
Thank you.
okay, so let's try to unpack all of that. The point that Shaw made is a very clever legal point. What he was trying to argue was, and it's touched on a number of the cases that the ICJ has dealt with, is to have a dispute. They require, if I could put it this way, that you exhaust, use a term that we would know, your domestic remedies, meaning that you actually engage with the other side, South Africa and Israel. And of course, Dugard was making that particular point that South Africa had. Shaw said, and this is, I think, the interesting point. Shaw said that Israel had offered to meet with South Africa to discuss this issue, and that Israel and South Africa had not followed up on that, and that therefore they had not, as it were, exhausted the internal remedies to an extent which essentially permitted them to approach the court. Now, that's an argument which would mean that what judges could then do would be to say, well, we don't have jurisdiction to hear this case, and goodbye. And thank God we don't have to deal with issues of genocide. And I could foresee that possibility. You know, you sit there, there's 17 of you. 9 of you suggest, or 10 of you suggest, of course this is genocide, right? Right? And then 7 or 8 say, no, it's not. And you're thinking to yourself, you know, we're worrying about the legitimacy of the court here. It's not good to have to have a situation of a 9-8 split. Really is not going to be all that helpful, because you can just imagine both sides will, claim, well, it was the kind of hack Russian who was on the one side, sort of situation. And so judges thinking about this, it's the easy way out. How many times as a judge, somebody's given me a thing, I think, I don't have to write a long judgment, this is fantastic, right? But I doubt that that's going to happen, right? I mean, I would have thought that it would be quite hard for them to take that case. And they may feel, deep down, that actually it was going to be useless anyway. And part of the reason for that is because of Netanyahu's statements consistently, we're going to finish this off, right? So, really, can you really argue that they're going to sit there and Netanyahu would have said, actually, I think we could do the following. So I think, judges thinking about this probably won't take that. But it was a very clever legal point that he took. The second point that he made, which was important point, very important point, he had to deal with the problem of Nikatoibi on behalf of the South African case, relying on statements of Gallant and Ben-Gvir and Smotrich. I'm extremely tempted to say something about them, but I'm not going to, right? All I'm going to say is this. Having made those statements in Netanyahu, if I was a lawyer advising the Israeli government, I would have said, you guys are going to be off your head, right? Please shut up and don't say anything, because those statements were indicative of an intent. What Shaw had to deal with in that regard was to say, you can't derive intent from that, because there are 2 fundamental sources of authority here. The War Cabinet and the leadership of the Israeli Defense Force. We've got a whole bundle. I haven't seen that bundle, no one has. The court, right? But what he read out, and you would have listened to that, were statements made in which, there was emphasis taken on worrying about civilian casualties. Now again, that is important, because what he was implicitly saying was, you can argue that those may not be enough. The leaflets may not be enough. They're saying you can't be careful about the way civilians may not be enough to protect you against a case under breaches of international law. But sure as hell, he's saying it must be to protect you against genocide. Because let us just, if we may, just look at the Genocide Convention for a moment. Not unhelpful to read the text here. You're a proper rabbi, you have to look at the Talmud, right? It's funny, this week's parsha, by the way, is about Pharaoh's hardening of the heart, not an entirely irrelevant issue to what we're talking about. But here we go. So it's killing members of the group. Right? It's acts committed with intent to destroy in whole or in part. Intent to destroy in whole or in part a national, ethnic, or racial or religious group such by killing members, causing serious bodily or mental harm to members of the group. I think that's the most problematic. Right? Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction, imposing measures intended to prevent births within the group, and forcibly transferring children of the group to another group. But all of those are covered by the intent to destroy that group. So what Shaw was trying to say is you don't even get to first base on this, because there isn't that intent. Because in order to derive that intent, look at what they're really saying, not what a bunch of people are saying where they shouldn't be saying. That was the strategy of his case, Mary. And the South African case was, by contrast, to rely heavily on those statements, as you heard, and to try to contextualize the dispute as whole, which is where Tal Blecher, the God, I wish we had someone on
was-
foreign affairs like that.
Yeah,
I'm not talking about the merits of the case again, but
No, he
what
was
an
just
incredibly impressive
Really was,
performance,
really was.
right? Really. But
So-
that
so
was
one
his
side saying-
argument. Sorry, carry on.
No, one side is asserting that South Africa's presented a watertight case, and others are countering that with saying that it offered no credible evidence to back up the genocide charge as defined, as you've read us the definition to the intention. It's not an opinion, genocide, it's an intent. You have to show intent. But what would you consider to be the strengths of the South African case and the weaknesses? actually?
Okay. The question in the South African case, again, let's go back to first principles. The South African case is a plausible argument. That is, could you plausibly argue? Could you make a rational argument, if it were, that what is going on there fits within this? And your argument would be, and it was, sorry, their argument was, number one, 85% of the houses have been destroyed. People have been all over the place as a result. And then you move them south, and then you bomb south, and you bomb north, etc. So the first argument was massive destruction of a kind. We got to argue what was your intent. Of course, the Israeli argument is opposite, but I'm saying that's a dispute. The second part of the South African argument would have been, of course, the statements made coupled with those
Are
actions.
you saying this is the strengths of the case?
I'm talking
Would
about the
you
South
think-
African case, yes. I'll
yes.
come to the Israeli case.
Yes, sir.
So, the third aspect of that would have been the cutting off of water and electricity. Now, there is no question that it's a breach of international law to impose collective punishment on a group. No question. So we can debate as much as we like. That is a problem. But whether that's sufficient is another matter. But they would couple that together with that. And then, of course, as you know, when you read the 84 pages, a long process which sought, I think, to counter the Israeli argument, well, if only Hamas had behaved properly, Gaza could have been a Hong Kong. Their argument was by controlling the egress and access to Gaza in the way Israel did, they were quite, I think the word they used, warehousing people there. And when you take all of that into account, we say there's and then of course the extraordinary amount of death and injury, we say that's a plausible case. That was essentially the South African case, plus one further factor. It was almost this, come on, they were saying to the court. You know, surely, you know, this is the kind of chicken soup argument, if you will say. It's better for you to give some relief if we can diminish loss of life than if you didn't. And again, that may be unpalatable to people listening to this, but I'm talking as a lawyer now and trying to read how judges would work. That's what I'm trying to suggest.
That's what we're doing here.
Yeah, no, that's right. But I think that's how we've got to think about that. The Israeli case was...
Sorry, just to
Yeah,
interrupt
sorry.
you. Do you see weaknesses in the South African case?
Yes, of course the weaknesses in the
I
South African
think
case.
we'd
And the
like to
weaknesses in
hear
the South
that
African case...
from
were-
your legal perspective.
Well, the weaknesses in the South African case were shown up by the Israeli case. And they were,
Okay.
and they were three or four. Firstly, you can't rely on their statements. Secondly, many of the killings took place because Hamas actually, their rockets went into the hospital, etc. Thirdly, of course, is the whole tunnel and the fact that they use civilians as shields. What are we supposed to do in such a situation? And fourthly, that actually the only group is actually intent on genocide is Hamas, not Israel. And those would weigh heavily with judges, obviously. Again, how heavily depends again on how far you read the plausibility point. I'm telling you, this whole case depends on that. It depends on the test. If the test is very low, but here's the thing. I think that the Israeli case, when it came to the dissection of the provisional measures, would have certainly been at least in part successful. So it wouldn't surprise me if South Africa gets some relief. It wouldn't surprise me at all if the court said, we can't order a country to cease fire when the other group who aren't before us. And I didn't buy Mr. Lowe's argument that, oh, well, Israel controls the process, so they can't rely on self-defense. I thought that was an absolute rubbish argument, to be perfectly honest with you. And so I think the argument made by Israel in that regard was very powerful. But what is evident from the way we're talking, I'm grappling with the confusing jurisprudence about the test. But because I think the test is very low, therefore the South African case, to that extent, is fairly strong. I'm not suggesting that all the South African advocates, were fantastic, not at all. I do think that some were effective, no question. And I also want to make this point. I was pleasantly surprised as a lawyer with the Israeli case. What I mean by that is, to a very large extent, they behaved like lawyers, and they dealt with it on a legal basis. I heard somebody from my own law school, who again falls into my category of knowing nothing about international law, talking on the morning before the Israeli case, and confidently suggesting all we're going to get is discussions about blood libels. And in fact, that wasn't at all. And I thought to myself, what the hell do you know? You got two very distinguished KCs from England. They're not going to argue that at all. And so I think, in a sense, that also belied another point, which I think is important, and we should learn from that, is that all the stuff about rubbishing the ICJ and all of that was such that the Israeli government, and I'm not a fan of that at all for obvious reasons, however, I think they knew something that a lot of the propagandists didn't know, was let's go there and put up a case on a rational basis, which is precisely why, if you followed what we're talking about, it's such a difficult case to call. This is not a case where you can say it's a slam dunk. As I say, I'm predicting certain orders may be granted, but that's because I think it's extraordinarily hard to say, if you're a judge, no, I'm not going to order that greater humanitarian aid should be provided. I just think that's why some of the orders... Now, the difficulty you face then is that, of course, depending on which way this goes, the one side will claim total victory. So assuming it goes the South African way, but on a modest provisional statement, I'm afraid it's going to be a lot of Sturm und Drang, which unfortunately, again, is not going to be accurate, but there we are.
Given that there's no appeal process,
None.
what are the mechanisms that the ICJ has to enforce their ruling?
They don't. If the ICJ find in favor of the South African complaint, of course it can go to the Security Council. The Security Council could pass a resolution instructing Israel as a member of the United Nations do the necessary. As you probably know, that's not going to happen because America will veto it. Although, again, let me just say this. I think you have to face, and this is a political as opposed to a legal statement, I do think it will place America in a more difficult position. Because if the judges do find that there's been breaches of the Genocide Convention, that's a hell of a thing to find, that it may put Biden under greater pressure. But even if they did make that resolution, it would have no practical effect. And I mean, the big irony about this case, and I'm forced to mention this, is of course, as you know, Ukraine got an order against Russia, and Vlad did nothing about it. And all I can say is, I haven't noticed a lot of protest in domestic quarters in that particular regard.
I think, Dennis, it's fascinating. As you say, it's a case that is gripped us all and the wider community, South Africa, the world in general. And how long before we hear anything, do you think?
They say it's about 10 weeks, so perhaps next week we'll hear something, and you'll have to, presumably as members of the board, etc., have to deal with that accordingly when they issue their
will we be given details of
they
Mr.
may well.
Mr.
They will.
Judge
They give a judgment.
But by each judge, will they tell you?
Well, that's an interesting thing. If you get unanimity, there may be one judge. I doubt that. Well, firstly, I have to say I have real sympathy with Judge Barak. This must be an extraordinarily difficult position to be put in. Assuming, I'm not suggesting one moment, assuming Judge Barak thinks that there are some measures which need to be taken, I mean, can you imagine him going back to Israel on that basis? Poor 87-year-old man. But it may well be that some judges, I'm not suggesting him, assuming, let's assume that that a majority of judges say that they think that this is a case better dealt with by the International Criminal Court, and that whilst not wishing to opine finally on this would be more appropriately dealt with under other international breaches of law. And as I said to you, I have no question that that's a much more tricky case. I'd be somewhat less circumspect on that than I am on this. But what I would say is that if, for example, some of the judges say that, other judges may say differently. So we could get 2, 3, 4 judgments. I don't know. They may be desperate here to find one judgment. If they do, then that would probably be, at best for South Africa, a more modest set of relief, if at all.
Okay, that's
But I'd be surprised if we got only one. And in many cases, I've quoted already here some of the cases, the Azerbaijan, the Armenian case, the Serbian case, the Gambian case. You see that there's more than one judgment granted in those given in those cases. Yes,
It's going to be really interesting.
Sure.
I know that there's a microphone for people who have, in the audience, who have questions, and also if there are any on Zoom, perhaps, Daniel, you could ask the questions on behalf of the Zoom participants. Thank you.
Sure.
Perfect. So the first question is, you may have touched on it, but when judges make the decision, do they get together like a jury, or do they make decisions as individuals, and then the final decision is simply in terms of the majority? That's the first question. I don't know if you want to answer it, and then
I'll answer it quite quick. Obviously, I don't know how the ICJ works, but I'm assuming they work like every other court, which is you have a conference of all the judges, and each judge will give their opinion. Now, it may well be at the end of the conference, or end of that, you've got 2 sides. Generally, then, the presiding judge would allocate, assuming that they're in the majority, would allocate, let's say that Judge Donohue's in the majority, she would allocate a judge to write that, probably on behalf of the court. Assuming the Russian judge is in the minority, he's the vice chair, I might add, he would allocate to another, and then they'd come back into conference and have a look. So at the end of the day, of course they have to discuss this. Of course the drafts will be circulated to each of the judges, because they've got to sign on. And remember, when you sign on, even if you've written a word, you're actually assuming that's your judgment. So, and then of course, it depends. You can have anything from there's 17 of them to a 9-8 split to anything else. As I've tried to indicate, I'd be surprised if it's unanimous, but it may be.
Okay, and then just the one question, then we can give it to the audience here. There was talk about the dispute of South Africa's process in engaging with Israel.
Mm-hmm.
They said that they contacted Israel and they heard nothing, and then Israel showed that they had emails or messages saying they were supposed to have a scheduling for the 2nd of January, and then the case was submitted. What is that process, and is that enough for them to dismiss a case?
Yes, that's what I said was the jurisdictional
you did
problem.
touch on that.
That's the jurisdictional problem. And just again to clarify for people, what I meant by that, what Shaw was trying to say was, because South Africa had not ultimately fulfilled the undertaking given by Israel to engage with it, therefore the dispute hadn't fructified, hadn't come to fruition to the extent that it should have seized the jurisdiction of the court. That has been tried. There are mentions of that in some of the cases, which is why he was right to raise it. But whether, in fact, they would be prepared to do that, which would have the consequences I indicated, that they would not make a decision and simply chuck the case out on the jurisdictional point, I'd be doubtful, but who am I to predict? Again, it's hard to know, since none of these judges said a word during the hearing.
Over to the audience here, if there are any questions. Gentleman here, yeah.
Hi. To the extent that provisional measures are granted against Israel, I mean, you've got 3 parties, 4 Houthis, you've got Lebanon, you've got Hamas, that aren't bound by this at all.
No.
To the extent that they are granted and they breach these provisions, where does that leave Israel?
Well, it depends what provisions are granted. That is why precisely the Israeli council who pointed to the weaknesses of the provisional measures. You may recall that the last KC
Yeah.
devoted a lot of, and he was pretty good, in terms of, as a lawyer, he was arguing that none of them are practical for the reason that you just advanced. Unquestionably, the most powerful of those arguments would be the argument that the ceasefire of one side, and so Israel would cease fire and Hamas would be free because they're not a party to have rockets and do anything else, is why the court would be reluctant to grant that. Some of the other measures there, including humanitarian aid, that's certainly something that I think judges would probably think is doable. And would almost be suggesting that the United Nations or international authorities essentially, as it would be subcontracted to deal with that.
My
Simone?
question is around the joining of parties. So now we've heard news that Germany is going to be joining in on
Yeah.
this application. A little bit Johnny come lately because they've already heard the provisional side of it. What is the process with regard to parties joining? How late can they join? Obviously, the full genocide case could go on for 2 years. And just onto that question, obviously there are a lot of considerations whether whether a party joins or doesn't.
Yeah, I'm not.
There are a lot of
I
issues.
honestly
Sorry,
don't.
just to
Yeah,
interrupt
sorry.
you, Dennis, I just wanted to repeat the question for the benefit of people on Zoom, because I don't think they could hear. So the question that Simon asked was related to parties joining onto the case. And that was one of the conversations that Dennis and I had. We've seen a lot of support for either side, but it's support from the sidelines. There's actually a legal process that countries or organizations have to follow, and I don't know who it's...
No, that's correct. That's correct.
And they have to actually, and in fact, to this moment, it seems that Germany's the only country that has formally, legally joined the case in support of Israel. So I think the question is, how long is it? Can a country join? We would have to wait and see whether there is going to be a long-term case, and then. But I'd like you to answer.
Yeah, I
the
don't
question.
know whether, you see, that's the point. I'm not sure. I was looking at the rules and I wasn't entirely sure because it wasn't clear. I'm also not sure what their attitude is, whether they're joining on the broad case or whether they now are allowed to make submissions in writing, presumably, to bolster, if you wish, the Israeli case.
Who do you mean by they, Dennis?
The Germans.
Okay.
I was assuming that's what they were trying to do. I mean, it's often true in these cases that you get all sorts of parties coming along in cases. If you look at some of these cases, you've got like 10, 15 different council teams. But my assumption was I thought that they were, in the normal course, you'd be allowed to probably make some written submissions. But we haven't read what the court did about that. It would have had to have, it can't again, given provisional measures, sit there and give them months to deal with that. So I'm not entirely sure whether their approach is we are joining this case so that when this matter goes to the full hearing, we there. That seems much more
So
logical.
is that a
to
form
me.
of amicus?
Yeah, I think that's more logical.
So what about all the noise that we've heard from countries around the world or organizations where they put out newspaper articles?
No, that's
saying we're-
irrelevant to the proceedings because at
it's
the end
just
of the end of the
solidarity,
day,
but
the
it's-
court's
yeah.
got to go by the record and by the submissions that have been made. Yes, absolutely.
I understand.
Could you touch a little bit further on the independence of the judges? And you also mentioned briefly you don't know if they're under instruction. There's no chance of the South African judge ever being pro-Israel or the Israeli judge being the pro-South African case over here. So are they there? Do the judges represent their countries? Are they under strict instructions? Or are they independent, brilliant legal minds who can make independent decisions?
Can we just check with Daniel? Are the people on Zoom able to hear the question?
Yeah.
I beg your pardon.
That's
Okay.
an interesting look. If you take the two that you're talking about, Barak and Moseneke, they're outstanding lawyers. And I have no doubt that the interests of the country were heavily on them. But I would imagine that if there was a serious argument, legal argument, one way or the other, they'd be sorely, they'd want to call it as judges. I don't think either of them wants to ruin a hard-earned judicial reputation by simply making a political decision. But these cases are inherently political. just by the nature of the case.
Is the court politicized?
Yeah. So yeah.
Not the judges necessarily, or is the court the judges?
Well, all of these. I mean, the problem about this case is it's an immensely political case for obvious reasons, and it's dealing with material, which, quite frankly, if we sat in this room, we'd have as many people as there are, we'd have double the opinions. But if you ask me, do they take instructions? No. I mean, I don't know what the Russian guy does. I haven't the slightest idea. But I mean, because that's a different. I deliberately mentioned all the others because they're proper lawyers. They are serious lawyers. And I would have thought they'll try to call this as best they can. And remember just one other thing. It's perhaps the difference between a jury and judges. Juries must just decide if you're guilty or not. Do not have to give reasons. True, they generally debate it amongst themselves, but they don't have to give written reasons. When you have to give written reasons and have to write down what you say, that's a much more difficult and constraining exercise. So if you've got judges like Barak may be absolutely torn by the virtue of the fact that he may know that there may well be some plausibility in aspects of the South African case, given the jurisprudence. I would say it's very difficult for him. Moseneke the same, but knowing Moseneke, if he felt genuinely that, let's say, there was a case that the test of plausibility was X, and that Israel didn't meet it, I'd be surprised if he found that way. But the truth about it is, just remember one other thing. Judges are not automatons. They're not like slot machines, where you put information into one slot and out of another one comes the answer. In every single case of a political kind, the judge's perspective counts. I only have to cite you the American Supreme Court now to know that. So obviously the judge's perspective does count. And very good judges will, in a sense, interpret something in a particular way. But would they simply take instructions? No. Would they be inclined to follow broadly their own government's policy? To some extent. But I would think that if they can't find a legal reason for that, then they won't.
Sorry, just the last question.
Yeah.
At the end, when the judgment is made, whatever it might be, however many judges decide yay or nay, will we get to know what each judge has actually decided?
No, you may not, because there may only be 2 or 3 judgments. There may be 1, because other judges may just concur. That's true generally. If you take a case, the Constitutional Court of South Africa, there are 11 judges. When the court's unanimous, one person writes the judgment, everybody else signs on. And you never know what happened in the conferences which took place where, the writing of the judgment by the scribe changed during the course of production because you as a judge said, I won't sign on to that. Let me give you an example here. We may get a position whereby, I'm not saying it's going to happen, but assuming you get to the point where the court says it's prepared to give relief of humanitarian aid, and that was the only relief it's given, they may have started with something broader. And then a number of judges would say, I can't sign on to that. And so finally the thing gets whittled down, but it still comes out in the name of a scribe, even though the other judges sign on to it.
So interesting, and it's been so helpful. Thank you so much,
My
Dennis. I know
pleasure.
you've got a very busy evening.
No, I got, unfortunately, yes. Sorry.
I know
You've got
there's
other questions.
anybody got any.
Oh, sure, sorry.
I'm
Why?
so
no.
sorry. I beg
I
your-
haven't stopped. I'm happy to carry on.
No rest. For
I'm
the
quite
witness.
okay
You
for another
have- you-
50 minutes.
Dennis,
Yeah, carry on.
just getting
Yeah.
warmed up.
Beg
Yeah,
your
yeah.
pardon.
Yeah,
Yeah.
maybe a question for the panel, as one of which Dennis, obviously a keen observer of all things politic in our country, and from a board perspective, sort of, holding the shield and protecting our Jewish way of life in South Africa. I guess my question is, whilst this case is all very emotionally intriguing and vexing, and has certainly, from my own perspective, galvanized sort of all thought processes to the exclusion of everything else, does the outcome really matter? And should we be, or how much time do you think we should be focused on, whilst our nose is so close to the page on the detail of this, academically, trying to understand it, how much time should we be allocating to understanding how this fuels a broader anti-Semitic bonfire, irrespective of what decision comes out of the court in our country?
I think that's a really important conversation, and I think for the purposes of tonight, and I'm going to answer your question, we were wanting our community and anyone who was interested to be comfortable and informed in terms of the content, the court, etc. The question you raise around, I think we're already in that space. We're already in the space where it doesn't matter. If you saw the, and I'm talking with my board hat now, very much on the record about where we are in protecting the Jewish community and this magnificent community that is definitely worth the fight. I think that's what we always have to remember. But if we saw what happened at Johannesburg Airport, where the legal team returned as if they were some, I don't know, the World Rugby team. So we're already in that space of it doesn't matter about what the judgment is. South Africa have, for reasons that we could go into, and that's a whole conversation for another hour and a half, have chosen this path, and it leaves us as a community deeply troubled and anxious. And we are taking on our government because we're finding it increasingly difficult. Manifestations of this are, the government is, through this action, empowering and enabling anti-Semitism on a level that we all know where that's going. And Cricket South Africa has a direct relation to this case. I personally believe that, and I think that it's becoming clearer and clearer. So the actual merits of the case are important to understand, and we're really grateful to Dennis for helping us with that. But the impact of the case on our community and on society in general, and global Jewry, for that matter. But I do also want to say that we, on that topic, have had unbelievable support from global Jewry. We stand together, and we are a united community who are troubled and going through a tough time. I'm not going to mince words. It's to pretend that it's easy, but it's a fight that we are putting a hard fight together for a community that is absolutely worth it.
I just want to say a couple of things, if I may. I think it does matter enormously.
Of the judgment.
In the sense that, assuming for the purpose of debate that the court, or majority of the court, comes down on the genocide side, or let me put it even further, that a further case, which is possibly very likely before the International Criminal Court, comes down and finds Israel guilty of crimes against humanity or war crimes. The effect of that is enormous, because the truth about it is then all sorts of people who may at this point have remained one way or the other will say, look, the World Court has found that. So it makes it, no question, it's a paradigmatic shift, whether we like it or not, depending on which way it goes. There is one further point, I think. I was struck the other night by somebody had sent me a clip of what Rabbi Mervis, the chief rabbi of the United Kingdom, had to say. Of course, he was 5 years behind me at Herzliya School, so I remember him. And he made a point that I thought was interesting. He didn't pursue it fully, but it's perfectly obvious. When he said, in the worst of times like this is, you need to have a paradigmatic shift. One of the great lessons of Jewish history is in our worst of times, we actually somehow move into a different paradigm and we survive. And he gave many illustrations. And the point he was making, and he said, we have these conversations with our Muslim community, and we have very nice tea and samosas, but the elephant in the room has never been spoken about, which is Israel-Palestine. And somewhere along the line, I don't know how this is going to happen, I don't know how to do it, but I sure as know it's got to be done at some point. We're going to have to confront that elephant in the room with people with whom we live. They live in the same town as we do. And you know, whatever they may feel now, we feel the opposite perhaps, we're going to have to deal with that. And that paradigmatic shift is the challenge that this community faces in all sorts of ways. Again, I'm not prescriptive as to how that's to be done. I just know it has to be. And I'll just give one illustration. I've been struck by 2 television programs I've done on this, in which I've had people on both sides. And I was struck, particularly the one that I did where with the Muslim representative on the side, who said to me afterwards, that was very fair.
With surprise.
And no, he didn't say but. He
No,
said,
I'm saying with surprise that he
I
would.
was surprised, but I was interested. And I think we're going to have to think very hard about how we deal with that. In other words, I think it's unhelpful to sort of not understand the fact that somewhere along the line we're going to have to face this problem. Now, obviously, we can't change Israeli policy, but that does not necessarily mean that we've got to have a conversation where we can understand each other. At the moment, we don't. They don't understand us, we don't understand them, and we should, and they should.
I think the point that Dennis is making is obviously very important, but I think there's what I was referring to is in between. I think the here and now, and it's not the
Yes,
suggestion.
I'm not talking about tomorrow morning.
Yes,
But
and
you
I
know-
think that the suggesting that the judgment doesn't matter was probably the wrong choice of words. But the damage for us, if that's the word, the heartache for us is already there.
Oh, that's true.
The heartache of seeing the hashtag RSA versus Israel, for me, is incredibly painful. So I think we're already in that space, and we look forward to the paradigm shift that Dennis refers to, hopefully.
Yeah.
Just a couple more legal
Sure.
questions now.
Yes,
Coming
thank
back to
goodness.
legal. This is a quick and easy one. Can a judge abstain?
Yes.
Okay, so that's answered. Thank you. Easy. The next one is, please would you expand on the concept of the responsibility to protect? Who holds that responsibility, and will that not impact on the judgment?
The text is he talking about? The responsibility to
I
what?
imagine so.
Protect.
To protect.
Yeah. That's the responsibility of anybody who's a signatory. And in this case, clearly Israel is a signatory. So therefore, the argument has been that the Genocide Convention, it's a very good question, by the way. The Genocide Convention is designed to protect ethnic groups or part thereof from ultimately the sort of tragedy that befell Jewry and other groups within the Second World War. That was the whole purpose of it. So there's an obligation to protect. Of course, South Africa argues that as a signatory to the convention, it has locus standi to get to court because it's an obligation to actually protect the beneficiaries of that convention who don't have the power to get to court. They're not a state as such. That's fair. I mean, and let me make a point. I think that's great, but I wish South Africa was consistent. If it had done the same for Sudan and Russia, I can tell you I would take a slightly different approach to all sorts of things, but let me leave that. But what I'm saying is that was the South African argument. The South African argument is, and it's true, if you're a signatory to the convention, then you have a responsibility to ensure that the convention is fulfilled. In other words, you have an obligation to prevent death or let's say serious bodily or mental harm in circumstances where there's an intention to destroy. Which would mean, and I think, let me just make one point on that which is not irrelevant to the Israeli case. One of the points made by the Israeli legal representatives was that if there are people who, and remember one of the issues here is direct and public incitement to commit genocide. Right? So if you make a speech saying an atomic bomb should be dropped on Gaza and they all should be killed, that unquestionably is a direct and public incitement to commit genocide. True, it's not by the country, but it's by individuals in the country, and that was why the Israeli representative said that's why the Attorney General has an obligation to prosecute people for that, because there was a recognition that a state has an obligation to ensure that occurs.
Okay. And then a final question, I think you may have actually touched on it now. The question, how does the court decide what weight to give to the statement by members of the Israeli government. So obviously the various ministers made comments.
Great question.
What is Israel's defense as to why these statements are not indicative of official policy?
Well, I tried to answer that, but it's a really tricky question. And as a lawyer, if I was arguing on behalf of Israel, I'd have to do what they did, which was to say, ignore those. Of course, the South African side says, well, really, you're going to ignore the Minister of National Security, the Minister of Defense, and the Minister of Finance, senior ministers in the cabinet? Sorry, if you're so worried about them, why are they still in the cabinet? Not a bad question, I might add, but that's another matter. So the problem is that's the tricky bit. The Israeli side is to say, if you're going to look for intent, you've got to look at actually the people calling the shots. They don't calling the shots. The South African thing is don't be silly. Of course they partly call the shots. Look who they are. And that's and that question depends on how far you go with regard to the question of genocidal intent. The Serbian case is the best exposition of that. And if you read that, certainly as a final case, it would be extraordinarily difficult to argue that those statements were themselves sufficient proof. But for provisional, the jury's out on that. Now we're going to have to see. And that's something that they're going to have to decide. My guess is that on that point, it's how much weight you place by the file. And I haven't read the whole file. That's one of my problems. I mean,
nobody's had sight of that file that they refer
I wish
to.
they, it would have been rather helpful if they'd actually said, so that some of us could actually, particularly for people trying to make sense of this, what does that file say? All we got was some of the statements within the file, which the judges have, but we don't have. Now, that's going to have to be weighed up. But all I'm saying is, I think statements of that particular kind, and let me make it absolutely clear, and I've heard some statements made in this country as well, by the way, which have really distressed me. I really don't like statements saying, you can think what you like about Hamas, but when you start saying these are animals, quite honestly, that should never be said. It's just utterly disgraceful. And it just creates a problem that actually is dehumanizing people. And you shouldn't be saying these things. And it's precisely because those statements have been made that Israel has got itself into the trouble that it has. But it's a very difficult question to answer. I can only say that what the Israeli representatives are trying to do was to say, well, people make statements, politicians make them all the time. But at the end of the day, if you're going to look for intent, you've got to look for the intent of those who are calling, if it were, the actual military shots, and those are only two, the IDF headquarters, as it were, and the war cabinet. Yeah. And so that's a very powerful argument, but you'll have to judge for yourself on that. I really don't know.
Judge for yourself. There you go.
Yes, there you go.
And Mary, I've got one final...
Glenn's got a question,
Glenn,
I think.
you go.
Because you're hogging the thing there,
No,
Glenn.
I've got two questions. We can get through them very
Glenn's a
quickly.
proper lawyer, isn't it?
One legal, one political.
Yeah.
Are there competent verdicts on the...
Are there?
Competent, I think I'm thinking back to law school, competent verdicts, as in we know genocide, but some lesser...
You'd have to,
offense.
sorry, I can say that, Glenn, that you'd have to make a provisional statement, a provisional finding, that there was sufficient evidence to say there could be some form of, that there has been a breach of the convention. The entry into giving provisional measures has to be a provisional finding on the Genocide Convention.
Yeah, I was actually thinking it's still the other kind of gradations of genocide. But I'm always in the second question, if you don't mind, a quick one, and it's purely political. What's your view on Frans Cronje's view about what drove the South African intervention? I don't know if you heard this theory. He put it out there publicly.
But the Iran thing.
Yeah. Does it sound preposterous, or is this going to happen?
I haven't the slightest idea, because last week everybody told me that South Africa runs because Russia pays the check. So what I do know is this, that the argument that is put up, that South Africa is part, the South African foreign policy, broadly speaking, is sort of aligned to this kind of BRICS type scenario, which is less orientated to America, etc., is, I think, a much more plausible explanation as to what's going on here. And let's be honest about it, you may not like this, but South Africa is now punching way above its weight in the Foreign Affairs Department, albeit not with and I agree, Greg Mills and Hartley, of course, say this morning, the Daily Maverick, this may cost us dear. in relation to the West. And thinking that
I was going to say there's been a whole discussion about consequences.
no.
in
There could be.
terms-
There could be.
in-
Mary,
in-
I'm not
in-
saying. I'm not,
I think-
but I'm just trying to say. I think whether you like it or not, the South African foreign policy has been looking more to the east than to the west, and I'm sure they're much more influenced by China, frankly, than others. But you know, I never like. Glenn, I always, probably as a lawyer, I always say, no, if you can give me some evidence, I'm prepared to buy that argument. Otherwise, it's like reading the Cape Times.
Thank you. Simon is going to close the evening. And again, thank you from me.
Pleasure.
And thank you from the audience.
Want me in the picture? Thank you, Judge Davis, for an illuminating analysis of what the ICJ case means for South Africa and Israel. Your time and expertise in such matters is deeply appreciated by the board and the community. On a personal note, I will always be grateful that it was never a good idea to show up to your tax lectures without preparation. Never a good idea to argue a legal position without a proper reading of the case. A useful and sometimes embarrassing lesson. The proper reading, interpreting, and engaging with the facts and the law is vital in every legal issue, the ICJ case being no exception. In an arena that is fraught with emotions and politics, it is valuable to go back to applying objective criteria and assessing the issues within the confines of the relevant laws. Thank you to Mary for moderating and to everyone who joined us in person and on Zoom. Good evening.
Thanks very much.
Thanks, Simon.
Thank
Thank you.
No, thank
Always
you very
nice
much.
to see you. Yeah. I'll be in touch. Get your. Yeah, I was going to say if you can, just maybe sometime. I've got a.
You know, the thing about nervous is he's actually a much better chief